I am Attorney Marie-Chris Bathan-Lasco. This is my virtual classroom. Welcome to my YouTube channel. In this channel, I shall aim to simplify the law. I shall discuss concepts and principles of law in under 10 minutes. Hi, in this video, I want to talk about the difference between a capitalist partner and an industrial partner with respect to them being able to enter into another business apart from the partnership business. So what is a capitalist partner? A capitalist partner is a partner who contributes money or property to the partnership, while an industrial partner is someone who contributes his industry or his services or work to the partnership. Now, if you are a capitalist partner or an industrial partner in a certain partnership business, are you allowed to enter into or to engage in another business? That is what we will be talking about in this video. So, if you are an industrial partner, again, a partner who contributes his services or his work or industry into the partnership, are you allowed to enter into another business apart from the partnership business? The answer to that question is Article 1789 of your Civil Code. Let's look into Article 1789. It says, an industrial partner cannot engage in business for himself unless the partnership expressly permits him to do so. And if he should do so, the capitalist partners may either exclude him from the firm or avail themselves of the benefits which he may have obtained in violation of this provision with a right to damages in either case. What does that provision mean? It means that, as a general rule, your industrial partner cannot engage in any other business apart from the partnership business. What is the reason behind that rule? The reason behind that rule is because what the industrial partner contributes is his industry or work. Definitely, he cannot divide himself. So, if he is to contribute industry to a certain partnership, then he must devote his time, his industry, his services to that partnership. In other words, he will no longer have time to devote his services to another partnership business. That is the general rule. The exception, however, is when the other partners would allow him to enter into another partnership business. Now, what if that industrial partner, despite being prohibited from entering into another partnership business or entering into another business, still enters into another business? What would be the consequences? As we have read Article 1789, your other partners will now have a remedy against this industrial partner who entered or who engaged in another business for himself apart from the partnership business. What are the remedies of the other partners provided for by Article 1789? Their first remedy is to exclude the industrial partner, plus they can recover damages from him. Why is that remedy available to the other partners? Why exclude the industrial partner? Because again, as we've mentioned, an industrial partner is supposed to devote all his industry or his services to the partnership business. And he has now engaged in another business. And this is detrimental to the partnership. So the other partners can exclude him from the partnership, plus they can recover damages. Another remedy, should they not want to exclude the industrial partner from the partnership, is avail themselves of the benefits that this industrial partner may have obtained in that other business. Plus, they can also claim damages. So these are the two remedies that are available to the other partners. First, to exclude him from the firm, plus damages, or avail themselves of the benefits plus damages. That is Article 1789 of your Civil Code. Now, how about a capitalist partner? Is a capitalist partner allowed to engage in another business apart from the partnership business? The answer is, it depends. It depends on what? It depends on what kind of business is this capitalist partner engaged in apart from the partnership business. Let's take a look at Article 1808 of your Civil Code. It says, the capitalist partners cannot engage for their own account in any operation which is of the kind of business in which the partnership is engaged, unless there is a stipulation to the contrary. This means that your capitalist partner can actually engage in another business apart from that of the partnership business, so long as it is not the same as that of the partnership business. The reason behind that is conflict of interest. Since you are contributing money to the partnership business, your civil code protects the partnership in a way that your capitalist partner should not be putting in money or property to another business having the same line of business as that of the partnership business. If it is not in the same line of business, then your civil code allows such capitalist partner to invest in that other business or to engage in that other business, because the reason behind the law is no longer present, and that is conflict of interest. Why is there conflict of interest? Because the capitalist partner may use the information that he may have gathered in the partnership business and use it in that other business to the detriment of the partnership. So remember that Article 1808 allows a capitalist partner to engage in another business so long as it is not the same as the business of the partnership. That is the general rule. The exception where the capitalist partner may still be allowed to engage in business the same as that of the partnership is when the other partners would agree to it. Now, what happens if a capitalist partner engages in another business apart from the partnership business, and such business is the same type of business as that of the partnership business? What would be the consequences? The consequences are actually found in that same article, Article 1808, second paragraph. It states, any capitalist partner violating this prohibition shall bring to the common funds any profits accruing to him from his transactions and shall personally bear all the losses. This means that if a capitalist partner, despite the other partners not agreeing to him engaging in another business which is in the same line of business as that of the partnership, the consequence is that that capitalist partner, if he has earned anything from that other business, he will have to bring it into the partnership. If there is any loss, however, in that other business, then he will personally bear the losses. The partnership will not have anything to do with it. Put simply, therefore, if you are an industrial partner, the prohibition to engage in another business is absolute. Why absolute? Because it does not matter what kind of business it is, whether it be of the same line of business or not of the same line of business as that of the partnership. Because again, what you are contributing is industry or services, and clearly you cannot divide yourself. How about a capitalist partner? If you're a capitalist partner, the prohibition is relative. Why relative? Because the prohibition will only apply to businesses that are in the same line of business as that of the partnership business. Of course, Either you're an industrial partner or you're a capitalist partner. The prohibition, as we've mentioned, those are the general rules. The exception is if all the partners will agree that an industrial partner can engage in another business, or the capitalist partner can engage in another business even if the business is in the same line of business as that of the partnership. That ends our video discussion on the difference between your industrial partner and your capitalist partner with respect to whether they can engage in another business apart from the partnership business. I hope you learned something from this video. If you have, please click like, subscribe, and that notification bell so that you will be notified of new video uploads. Thank you for watching. See you next time in MBL Classroom.